Hello, I'm Locke Meredith with Legal Lines. Today we're going to talk about why you want to hire an attorney. If you do hire an attorney, what do you look for? Do you trust them? Do they look like they know what they're doing? Do they look like that they would be a good negotiator for you with the other side? And if you can't reach an agreement, are they going to represent you well in court? We're going to talk about what it's like to have a personal injury claim and the process of coming in and hiring a lawyer, and what do you sign, and what do you do, and what are they supposed to do. So join us today with Legal Lines. I'm Locke Meredith. Thank you. Welcome. I'm Locke Meredith with Legal Lines. I have on the show today with me Sean Fagan, my partner in the practice. We're going to talk to you about why you want to hire a lawyer, or if you want to hire a lawyer, and what the process is like. Sean, let's talk about it. We see a lot of folks walk in the office, and frankly, they're not very happy usually to be here. And they're uncomfortable because they don't know what to expect. So let's talk about that.
Generally, you don't have someone who walks in as a veteran. They walk in, it's the first time they've been in an accident or had something go wrong, and they're looking at some significant financial difficulties. A lot of times, if it involves a car accident, they may have lost use of the car. And so they're coming in a situation where they have no transportation. They may have medical bills that are mounting, and they come in and ask for assistance, and that's where the whole process begins.
And so what we do is hopefully try and make them feel comfortable. They'll sit down basically where you're sitting, and generally we'll have a form that we use, and we'll ask them questions. We'll find out what happened, when did it happen, and if it's, for example, an automobile accident, we'll get the facts about that. If it's relating to a contractual dispute, find out what it's about, who are the parties, what are the issues involved. And so we try and accumulate facts, and that helps us what?
Well, it helps us evaluate the case, but more than anything else, a lot of times you have people, at least in my situation, they'll come in and they'll ask, why are you asking these questions? What's important about this? Well, generally because over the years you learn what the insurance companies will ask, keeps us from having to have the clients come back and forth on numerous occasions to answer the same questions. But I think that one of the major things that we have to deal with is the time element. How much time has passed since the date of the accident? Because a lot of times people will try to negotiate with the insurance company itself. And we have, as you know, in Louisiana, generally a one-year statute of limitations.
Let's talk about the personal injury type of interview, because that's primarily what we deal with. The folks will come in, they've been in an automobile collision generally. A lot of times they've already been to the emergency room. They're hurting. They're not sure whether or not they want to go see another doctor, or if they do need to go, who to go see. And they're also getting a phone call a lot of times from the insurance company of the fellow who hit them that wants to talk to them, and they're not comfortable about that. Generally, we tell them, don't talk to them, don't we?
Well, there's a good reason, because most people are not experienced or prepared for that type of situation. You've got usually an adjuster who may have had 10, 15 years experience, and they're asking questions that potentially are really not in the best interest of the client, but in the best interest of the insurance company itself.
They're not trying to find out why they should have to pay. They're trying to find out why they shouldn't pay, generally.
That's right.
We were talking about the time frame. Folks probably know, but they got 1 year from the date of the accident to file suit. And if they don't file suit within a year, it doesn't matter how hurt they are, or it doesn't matter how high their medical expenses are, it doesn't matter how many jobs they've lost because they couldn't go to work. It's over with, and they're not going to get compensated.
Sure, and many times I've had people come in and say that I've been dealing with the insurance company for the last 11 months, and they've promised to pay this, they've promised to do that, and it just hasn't happened, and now I'm frustrated and I think I need to hire an attorney. And at that point, as attorneys, we usually go into overdrive because you've got a month left, and it doesn't matter what promises have been made by the insurance company. If the year has passed, you've lost your right to sue generally.
There's usually two issues we're faced with in these types of cases, and that is the property damage to the vehicle and then the personal injury. Let's talk about the property damage side. Somebody runs into the back of me and my car doesn't work now. What do I get to do? What do I have to do?
Well, a lot of it depends on the type of coverage you have. Sometimes we have situations where the person who got hit, who is not at fault in the accident, has collision coverage. In that case...
Meaning with their insurance company.
With their own insurance company. In other words, they buy optional coverage, and then they can go to their own insurance company and say, listen, we're still working it out with the other person who hit me, but in the meantime, I need to have my car repaired.
Now, they'll have a deductible customarily under that type of coverage, and it can range from $100 up to $1,000.
That's right.
So that may help them decide whether or not they want to submit the claim under that aspect of their own policy or try and make the other guys who are at fault pay. But if they've got a low deductible and they're missing work and they got to have some money to pay the bills, then generally it's our advice that they go ahead and submit it to their own insurer so that they can get that car repaired.
Sure. I mean, to get them back to work as soon as possible, that's the best scenario, and then on other occasions that may not be an option.
Because they don't have that kind of coverage.
That's right. They don't have collision coverage, and then their only option is to go against the insurance company for the fellow that hit them.
And those guys aren't always cooperative, are they?
That's right. It may take time to investigate the claim. They have to send an adjuster out there. They conduct interviews. In the meantime, if you have no transportation, you're missing work, and oftentimes the employer can't afford for you to miss work and you lose your job.
Now, the person that hits you, they're not only responsible for the damage to your vehicle, but they also owe what's called a loss of use, or you have a loss of use claim if someone hits you and now you can't drive your vehicle for each day that you're without the use. A lot of times the other insurer will go ahead and they'll pay for a rental vehicle, but a lot of times they won't, and you have to present that via petition, a lawsuit, if that insurer doesn't help.
If the insurance company doesn't offer any type of rental reimbursement, that's your only option.
Now, sometimes there may be that type of coverage under your own policy, but generally I'm finding that most folks don't have it because it's pretty expensive.
That's right. I'd recommend that people have it. It's a good safety net for you because then you're not at the mercy of the other insurance company. But oftentimes that's not the case.
The other aspect of the property damage claim is, hey, somebody hit my car, and even though it's working now and fixed and looks all pretty because it got all that nice paint on it, it's still not worth as much because if somebody asks me when I'm trying to sell it, has it ever been in a wreck, they're going to walk away or they're going to want to pay less. It's depreciated in value.
That's right. It's generally called a diminished value assessment. And it's really a growing industry in the United States right now where there are industries or entities that go out there and actually look at the repairs done to the vehicle and try to see if it's devalued the car. And then you can also assert that as a claim because you've suffered a loss. If you wanted to go sell that car tomorrow, and I had one just the other day where someone came in with a 6-week-old Suburban and had $12,000 worth of damage done to it.
Car's not worth the same, is it?
Car's not worth what it was before that accident. So if they had to trade in that car or sell the car, the dealership they bring that car to is going to inspect the vehicle. They're going to look to see if there was any evidence of damage, and if there was, you're going to take a hit on it.
The other aspect of the claim is we've talked about loss of use, depreciation, and of course the repairs to the vehicle. The other aspects that we look at is what other types of insurance coverage are there, because we have medical expenses. That's a loss that's being incurred, and under your own policy you may also have what's called MedPay insurance. Let's talk about that.
Medical payments coverage, just like collision coverage, is an optional coverage. You can purchase that, and if you do purchase it, it protects you for any medical expenses you incur.
It's like health insurance.
Yeah, and regardless of whether it's your fault. If you run into an oak tree and because you were changing the stations on the radio and you have $2,500 in medical bills, you can go against your own medical payments coverage and they'll pay the tab.
And that also pays medical expenses for the driver or anyone who was in the vehicle with them.
That's correct.
Now, oftentimes I'm seeing it limited at $1,000, usually no more than $5,000, and I certainly wouldn't recommend more than $5,000. Would you agree?
I'd say $5,000 would be adequate under most circumstances.
The other things we deal with, of course, we talked about property damage, and the medical expenses is the bodily injury part of the claim. And that is someone who's been hit and they've suffered a bodily injury and they've gone to the hospital or their doctor and they're continuing to treat. Let's talk about that aspect of the claim.
Well, bodily injury is of course, to put it in context, if I have a vehicle, I'm driving it and I wind up running into you. I'm at fault for the accident. And then at that point, it's up to you to come after me to be compensated. It's liability for me, and the coverage is going ahead to pay you off, essentially,
All right,
for the damage I've done.
Let's talk about the bodily injury claim when we come back. This is Legal Lines with Locke Meredith.
What is a hero? Are heroes born, or are they made? In after-school programs, your kids will uncover hidden strengths and find the hero inside themselves. Let us know you want after-school programs in your area. Call 1-800-USA-LEARN. After-school programs, helping kids find the hero within.
Welcome back. I'm Locke Meredith with Legal Lines. I'm talking today with Sean Fagan, an attorney here in town, and we're talking about hiring a lawyer. Why do you want to hire them, and do you need to hire a lawyer? And we're talking particularly in the context of a personal injury claim, if you're injured in an automobile accident or at work or something like that. Sean, we were talking about the personal injury claim. We talked about that you have a property damage aspect, usually where the car is damaged. You've got medical expenses that you've incurred, and you want to get those paid and taken care of. And then we talked about the fact that someone's injured and they can't go to work. How are they compensated for that?
Well, obviously the beginning is, we referenced earlier, was the hiring aspect of it. And it starts off with the person coming into your office basically telling the story of what happened. And the primary thing that people have to understand that haven't never hired an attorney before is it's a voluntary process. You're essentially interviewing your attorney. You're trying to see if there's a rapport, if the person seems competent, and if they're responding to your needs. Should be the overriding issue when you're hiring an attorney, is do you feel that the person knows what they're doing, and are they interested in you as opposed to just the case itself and putting it to rest and moving on to another case as soon as you're gone.
And the reason that's important is because this is the person who's going to represent you in your losses. Like we said, property damage, the medical expenses, your lost wages, the injuries that you've had. And if they know what they're doing, they're going to be able to do that in a logical, organized fashion that hopefully is most productive for you. The hiring process is interesting because I liked what you said, and that is the person coming in is deciding whether or not they want to hire that lawyer. They don't have to hire that lawyer. They've got a gazillion million guys out here who are lawyers. And so the issue comes down, do they feel like they're going to trust that person sitting across the desk from them to represent their interests?
Well, sure. I mean, ultimately, most people realize that not all cases go to trial. The vast majority of them settle prior to trial. And so the last thing that's going to occur is when your attorney calls you and says, they've offered this amount of money for your claim, I am of the opinion you should accept it, reject it, or keep going. And ultimately, that turns on your faith in the attorney.
Right.
If you trust them and you feel that they know what they're doing, you're going to ultimately take their advice.
The attorneys, if you hire an attorney, what you do is you come in, you interview them. If you like the way they present themselves and they seem competent, then generally they're going to have you sign a contract. And that contract basically sets forth the agreement, generally saying that you're hiring that person to represent you in this particular matter, that they're going to either advance the costs out of their own pocket or they expect you to do it, or if they do it, then you're going to have to reimburse them. Sometimes it's limited to only if you recover money for them. It also usually provides that the fee, which is what most people care about, and the fees generally range from 1/3 to 40% of the gross recovery that you realize for that person.
Now, the biggest issue that pops up a lot of times in that first interview process is, what is a contingency fee, which is exactly what you're referring to. That's a situation where the client comes in, hires me, and I may incur a lot of expenses up front. Basically, I don't get my money back that I put out on a case unless I get a recovery for them. I am taking a risk. Now, that's different from an hourly situation where they come in and they may hire an attorney. A lot of times attorneys charge between $100 and $150 an hour.
Those are generally lease, contracts, business disputes.
That's right.
In the personal injury area of practice, it's usually a contingency fee.
That's right.
Which is a piece of the pie.
Exactly, because people could not afford to come in and hire an attorney for $150 an hour.
Not many folks.
Not many folks, because they'd want the money up front in a retainer fee, or some type of retainer amount. And if the people can't come up with it, they simply are left without an attorney. The contingency fee contract was created really to allow people who don't have the money in their pocket to pay for an attorney to get representation.
Right. Let's talk about the personal injury aspect. Generally, the folks are coming in, they're injured, they need to go see a doctor, and as you've indicated, usually they don't have a whole lot of money. And so oftentimes, the attorneys will refer them to a physician to provide care to them.
That's right. A lot of times they're attorneys that, in our case, we have pretty decent-sized practice that's been in existence for a long period of time, and over the years you have experience with doctors throughout the city. And we have at least the benefit of seeing doctors that are great doctors, doctors that are good doctors, and doctors that aren't so good.
And it doesn't mean that because we send you to a doctor with whom we've dealt with in the past that that doctor is going to do something wrong or lie for us or anything of that. Those are guys that are treating patients, and the person that is referred to them is just another patient to them.
That's correct.
But a lot of times folks, I think, get the impression that because the lawyer has sent someone to a doctor that somehow that doctor's in their pocket, and that's just not the case, is it?
No, it'd be foolish for the doctor to do that because ultimately he's giving up his reputation for a single case or a single attorney. Generally, the reason why I would send someone who's hired me to a particular doctor is because they have a good reputation in their specialty. I may have folks that come in with back injuries, or they may come in with a hand injury, and I've dealt with 15 doctors over the years that do hand work. And if I feel that from feedback from clients over the years that they were really satisfied with a particular doctor and he did good work, then sure, I'm going to tell my client, listen, this guy's got a good reputation. He's a pretty fair guy. I would suggest you go see him.
Let's talk about the situation where someone is injured, they're coming up on a year from the date of the accident, and they haven't yet filed a lawsuit. You've got to file a lawsuit within a year, or that claim's gone.
That's right.
And then if after the year, it seems like the fellow's doing better, but then later down the road he develops additional injuries, if you've settled that case or taken it to trial, it's over with. You're not getting any additional compensation for the injuries that surface down the road, are you?
That's right. Once a settlement or a judgment's rendered, that's the end of the case. The bigger question that usually pops up is, what happens if I'm in an accident, I don't realize that I've been injured, 3, 4, 5 months go by, and I'm feeling pretty good, and then all of a sudden, as I develop some aches, I eventually go to the doctor, and 6 months down the road he says, guess what, you were injured in this car accident, and you've got to have surgery.
But a year's lapsed.
Well, let's just say that the year hasn't lapsed, that we're 6 months into the year. There are situations where the law takes that into account. And I believe the test is that once you've been put on reasonable notice, and reasonable notice would be where things are going on with you that would cause you to investigate it further. For instance, you have significant problems with bending your arm. And if you ignore it for 6 months, well, the law is not going to give you any grace on that. But if you haven't had any problems and 6 months later your arm starts developing a lot of pain, then you go in and then it's diagnosed and then it's related to the injury. In certain instances, that first 6 months may not count against you.
Well, a lot of times it boils down to whether or not the doctor ties it to the trauma, the particular trauma in the wreck. And of course, the doctor is relying on the veracity or the truthfulness of his patient. If there's a big gap between the accident and when you go see the doctor and nobody believes you, well, you're not going to do very well. But if the doctor believes you and he attributes it to the collision, then you're probably going to be in good shape. Let's follow up with that on the next segment. I'm Locke Meredith with Legal Lines.
I wasn't going to school because I was making money stealing cars. Well, I was 10 when I first got involved with drugs. I skipped school because, nobody cared.
When I first got pregnant, school was not important to me, so I dropped out.
Well, if I don't finish school, then I can't go to college. That's the whole point of what I want to do with my life.
I still need to go to school to make it for myself.
I think I'm happier now. I know I'm happier now.
Welcome back. I'm Locke Meredith with Legal Lines. I've got Sean Fagan on with me today, and we're talking about why you want to hire an attorney, if you do, and what's he going to do for you. Sean, we talked about in the context of a personal injury claim, the process. You hire a lawyer and what he's going to do for you. And we talked about you've seen a doctor, and let's say the doctor says you're healed. What do we do next?
All right, at that point, once we've got a clear picture of what the future is for you, it's safe at that time to go ahead and start putting together what we call a settlement package. That would be a document that basically, the way we do it in our practice, would summarize all of the medical expenses that you've had. It would summarize all the treatment that you received, and then it would also include a section that would evaluate the pain and suffering aspect of your claim. Those are generally broken down into special damages, which of course are your medical expenses, lost wages, out-of-pocket expenses for prescriptions, damage to your car, and then there are general damages, which is the pain and suffering aspect, which is the part that is probably the most
Not crystal clear always.
yeah, that's the harder one to grasp.
It's very important also, before we put together the settlement package, that we're convinced that the client is healed, because oftentimes they'll say, I'm feeling better, and then a month down the road they're not feeling better, or they continue to have this periodic problem in the arm, let's say, numbness and tingling down into the hand, but they think they're okay. Well, it's not time to put together a settlement package, because, as we said before, once you settle or go to court, it's over with. And we need to make sure that the client is fully healed, or that they've seen every particular expert doctor that they need to see, or had every kind of test to rule in or out whether or not they've got a serious injury. Because if we don't deal with it prior to settlement or going to trial, they're not going to be compensated. So it's very important that they see the right doctors and they get the right tests, isn't it?
That's right. I mean, the settlement package is really based on usually the doctors saying that things look clear. Oftentimes you hear, situations where someone may say, I can get you a settlement in a week, I can get you a settlement in a month.
Have you gotten your check?
Have you gotten your check yet? Yeah. That could be in the worst interest of your client. It may be in the best interest of the attorney, but the worst thing you can do for your client. Because just as you said, once it's settled, that's it. And if you have major problems that develop a week after settlement, you're going to eat the cost for those problems.
So we talked about the settlement letter. It's summarizing the facts. It summarizes the medical treatment. It summarizes the medical expenses, the wages that they've lost. If they've got an injury that inhibits their ability to work in the future, it summarizes their future lost wages. And if they got an injury that's going to require continued medical care for the long term, then it's going to have a summary of that. Then, as you indicated, we have a section that deals with what we call in our legal jargon general damages, but all that is compensation for the mental and physical and emotional pain and suffering, their scarring, and aspects that are really hard to quantify, like all those lost wages and medical expenses. And then we send it to the insurance company, and what do?
At that point, the insurance company is going to evaluate it, and they're going to do some of the same things that we do. And typically, they're going to respond with a counteroffer. It's very rare in my experience.
I've never had it happen.
You anticipated what I was going to say. It's very rare, if ever, that it occurs where the insurance company says, sure, this is a perfectly reasonable settlement demand, we'll pay it 100%.
It's on the way.
That's right. And when that happens, I'll probably be 80 years old and finish practicing law. Generally, it's a counter. They'll send a counteroffer.
It's a negotiating process. And this is another aspect that I think folks need to be very comfortable with when they hire a lawyer, and that is that guy, in their opinion, knows what he's doing, he appears competent, and he looks like he's going to be good at that, because that's a lot of the practice of law, is negotiating and standing firm when you need to stand firm, and making sure you've dotted your I's and crossed your T's, and you have all the evidence to support your position. Because if you've done that, reasonable people can generally reach an agreement.
Sure, and they've got to start with from the standpoint of recognizing that the insurance company's job is not to give away money. There's a lot of press out there that says, well, these settlements are huge settlements, and how can this be going on? Well, hey, the guys on the insurance company side are very skilled.
They have to agree to settle.
That's correct.
A voluntary agreement.
That's right. You can't force someone to settle, and they're certainly not going to settle if the case is worth $10 and not going to give you $100. They wouldn't be in business.
Now let's talk about the situation where the person who's hit you doesn't have enough insurance, and your damages, let's say, are $100,000, and he has that minimal limits policy as required by Louisiana of only $10,000. We've got a $90,000 difference. What do?
Well, that's when you pray that your client had the foresight to get uninsured motorist coverage.
And you know what's so frustrates me so much, and that is most folks don't have a clue what uninsured or insurance does for you, and it's what I just described. If the person who hits you doesn't have enough money to compensate you for your injuries, you can go against your own insurance company for the difference. In our case, we were saying all he had was 10. We have $100,000 in damages. We can now go against our own insurance company for that $90,000 difference if we've paid a premium for that amount of coverage.
That's correct. And in Louisiana, it's mandatory that uninsured motorist coverage is included with any insurance policy issued on an automobile. You have to waive it, and if you don't waive it, you have the option of reducing the coverage down to a minimum of $10,000.
And let's talk about how important that is. Let's just restate it. By law, in Louisiana, if you buy a liability insurance policy, you automatically get this uninsured motorist coverage, which again pays for what the guy has and what your damages are, that difference. Or what if he has no insurance? It pays for that situation too. It's provided automatically by law unless you waive it. How do you waive it?
Well, in recent years, Louisiana Department of Insurance has now provided a form that has to be used by the insurance company, and it details your rights regarding uninsured motorist coverage and your option to waive it or your option to reduce it. The only way that you can lose coverage or have it reduced is if you've signed that form and provided it back to the insurance company.
And so our advice to everybody is do not waive insurance. And if you do not have it, call up your insurance agent and tell them you want it. They've got to give it to you, and the premium that you pay for that coverage is minimal for the amount of coverage you get with the number of folks who are driving with only $10,000 in insurance coverage or with zero in insurance coverage. It's one of the most important insurance coverages you can get, isn't it?
Sure, and we don't get a commission off of that. It's just in experience you see how devastating an accident can be when someone doesn't have enough coverage.
It's incredible. Let's talk about what happens when you just can't reach an agreement with the insurance company. What do we have to do then?
At that point, it proceeds to the litigation phase. If a suit has not already been filed, at that point, you know that settlement negotiations are not going to lead anywhere, so now you start putting your ducks in a row to actually get in front of a judge or a jury to have them decide the issues.
And when we say the litigation process, it's filing the lawsuit, suing the other people who are at fault, suing their insurance company, getting all the information in a formal process, taking depositions, recorded statements of all the various players, and going to court and basically presenting your facts and your story to the judge or the jury and letting them decide.
That's right. That's what our civil system is based on, is ultimately you put yourself in the hands of the other folks in your community or in a judge, depending on the value of the case.
I want to go into greater detail on our next show about the litigation process. Thank you for being with us. I'm Locke Meredith with Legal Lines.